Okay, well, good afternoon, everybody.
All right.
Please be seated. It's good to see you all and welcome. I'm sorry about the lack of space here. There are some chairs up here. Those of you who are still standing, we'd be happy to have you sit in those chairs. There's a couple chairs up here as well. You prefer to stand? Okay. Let me, I think what we're going to do today is, Mr. Loeb, you probably were there because Mr. Bell is the first defendant alphabetically. I think what I'm going to do is start over with the Crute case if I could. So would you kindly change places with Mr. Olson? And let me call the case and then I will explain generally the process we're going to follow this afternoon and how we'll go about making sure that everybody who wishes to be heard has that opportunity. So, begin with the case of State of Wisconsin versus Mr. Michael Crute. It's case number 13 FO 2108. State appears by Assistant Attorney General Rebecca Weezy. Attorney Jeff Scott Olson appears with Mr. Crute, who is here in person this afternoon. Let me begin by just giving sort of an overview of what we have. I want to assure everybody that I have read everything that has been filed. I got a couple letters today, and Ms. Weezy did file a brief in the Chusin case, which I take it probably is very similar to the other ones, and so I have not had a chance to read that brief, but other than that, I have read everything that has been submitted, so please know that, and the lawyers that will be arguing and the individuals who are representing themselves, you don't have to repeat what you said in the brief. I have read it, and the reason that we're having these arguments today is because I want to give everybody an opportunity to say whatever they think I should know before reaching a decision. The calendar says that these are set on for oral rulings. I anticipate having oral argument today. There may be some things that I rule upon today. It's very likely, though, that I will take other things under advisement and I will have a decision out within the next 30 days or so as to whatever I take under advisement. So with that then, I will be calling each of the cases individually, and we will begin with the Crute matter. And Mr. Olson, it is your motion to dismiss. I'd be happy to hear anything you want to add to that motion by way of supplementation or other argument.
Your Honor, we've limited our constitutional attack on the provision under which Mr. Crute is charged to one argument, and that's that section 2.14 sub 2 sub b sub 5 is unconstitutional on its face because it's not narrowly tailored to serve a significant government interest. Our argument is based on the language of the enactment. On its face, it requires government permission for expressive activity, in this case in the Capitol Rotunda, by very small groups and individuals, and the federal court has already held that that is not a narrowly tailored provision based on authority from all over the country that says that permitting requirements that sweep within their ambit very small groups and individuals are not narrowly tailored. The state's only response to us, I think, is that Judge Conley gave them a narrowing construction of the enactment at issue that renders it constitutional. What we tried to show in our reply brief is that there is a difference between a narrowing construction or a narrowing interpretation and a limit on enforcement that is placed by a federal court in the manner of a preliminary injunction to hold the line on certain unconstitutional conduct while a case is pending. And it's very clear in Wisconsin that a court should adopt a constitutional construction but that the construction has to be available from the face of the enactment, from the language used in the enactment. And in the cases that we've cited in our reply brief, we provided illustrations where the Wisconsin Supreme Court could not impose a narrowing construction because it could not find in the language of the enactment at issue the semantic tools for a narrowing construction. And we've also provided an illustration of one case, the Seventh Circuit case in Schultz versus City of Cumberland, where the court did find the grammatical tool, if you will, in redefining a particular word, in that case the word regular, to achieve a constitutional reading of the statute. Those word tools that the court would need to construe the section at issue in a constitutional fashion are just absent, and the court can't do it. The court should declare this provision unconstitutional on its face and dismiss the charge against Mr. Pruitt. Thanks.
Thank you very much, Mr. Olson. Before we turn to Ms. Weezy, a few people have joined us. Feel free, we do have some chairs up here. You're more than welcome